I stood at the edge of my grandfather's meadow and counted 96 front doors where there used to be wildflowers. Condos, 3 stories, built on land that belonged to me. And by the time I was done, every one of them legally was. It started because a woman with a clipboard thought I was just an old man who wouldn't check. I found out by accident, the kind that rearranges your entire life in the space between one heartbeat and the next. A friend wanted to scout for deer that fall. We drove up the county road, came around a curve expecting tree line, and there was a paved entrance, stone columns, a brass sign, a gate arm, buildings, parking lots, a playground. My friend said, "Wrong turn?" I pulled up GPS coordinates from the survey I kept on my phone because I'm a retired land surveyor, 31 years with the county, and I keep files like that, and looked at the pin, then looked at the sign. I was standing on my property. And I knew something before I could prove it. This wasn't a mistake. Someone had built a neighborhood on it, with paperwork that said it was theirs. What the HOA board president didn't know, what she couldn't have known, was that I'd spent those 31 years as a licensed land surveyor, the last 9 as chief. I signed off on every subdivision plat recorded in the county, every one. I knew how to read a plat map the way a surgeon reads an X-ray. And the document she'd used to steal my land, I could tell it was a forgery in under 4 minutes. But I didn't say a word, not yet. If stories like this remind you why ordinary people should never be underestimated, subscribe and join this community. We're just getting started. The property came into my family in 1947. My grandfather, Earl Dutton, bought 43 acres outside of Leland, North Carolina, with cash saved working maintenance at a paper mill for 19 years. $800. I still have the receipt, handwritten on cardstock, tucked inside the original deed in a fireproof box. He built the farmhouse himself, foundation stones carried by hand from the creek bed. My grandmother said he never asked for help. I grew up in that house. Light came through the east-facing kitchen window every morning and hit the counter in a band of gold. I still drink my coffee in that light. My father added the workshop in '71, Finnish carpenter. His workbench was a single slab of white oak, sanded smooth from decades of use. That land wasn't just acreage. It was the only place left where I could still hear the people I'd lost. My wife, Linda, passed in 2016. Cancer. Quick and unfair. After she died, I'd walk the south fence line, along locust posts my grandfather set in '52, silver and hard as iron, and I'd talk to her. That was my life. Quiet, built on ground I understood down to the inch. And someone had already decided it wasn't mine anymore. When Dad passed in 2003, he left me the 43 acres, clean warranty deed, properly recorded. I filed the executor's deed, paid every fee and tax, did everything right. I want to be specific about that, because later, people tried to suggest I hadn't. By 2018, the property was worth maybe $620,000. Leland was growing fast. A man in a silver SUV offered $400,000 for the south 11 acres. I told him no. He said I'd regret it. I told him I'd been regretting things for 60 years and hadn't died from it yet. Then a woman named Diane Kessler knocked on my door, and that's when her plan started. Diane moved to Leland from Northern Virginia in 2016. Within a year, president of the Briarwood Commons HOA. Nobody ran against her. I learned later she'd recruited 2 candidates, then talked both out of running the week before the election. That was Diane. She didn't win elections, she engineered them. She showed up in April 2019, clipboard, blazer over a polo shirt. She introduced herself with her full title, the way someone presents credentials at a border crossing. She had this phrase she used constantly, as a matter of protocol, put it on everything. She didn't argue, she declared. And she nodded while people spoke, not because she was listening, because she was waiting for them to finish being wrong. She informed me my south fence was encroaching on HOA common area. She had a printout, a satellite image with a red line drawn in what looked like Microsoft Paint. I told her I was a retired land surveyor. Something shifted behind her eyes, just a flicker, and the smile came back, practiced, no warmth behind it. Well, she said, sometimes a fresh set of eyes helps. But here's what I noticed. She didn't look at the fence when she said it. She looked past me, past the house, past the workshop, toward the south meadow, like she already knew exactly where the fence was and wasn't interested in it at all. 2 weeks later, certified letter, relocate the fence within 30 days or face legal action.
My fence was exactly where it had been since 1952. I'd surveyed it myself, twice. I wrote back with copies of both surveys in the original meets and bounds description, certified, return receipt requested. She never responded, but things changed. Next came the covert, then the workshop, visual blight inconsistent with community aesthetic standards, then code enforcement. Not because she expected to win, but because she was building a record. An inspector came out, walked the property, looked at my hayfield, looked at me. "Mr. Dutton, I don't see a violation here, but someone's gonna keep calling." She wasn't fighting over 6 feet of fence, and I was about to find out why. I attended a Briarwood board meeting in June, sat in the back. Diane spent 11 minutes discussing the Dutton property situation without looking at me once. She described my land as an unmanaged rural holdout creating liability exposure. She used fiduciary obligation 3 times in 40 seconds, each time slower, like she was teaching it to the room. I raised my hand during public comments, stated that my property was not within HOA jurisdiction. Diane interrupted. "Mr. Dutton, as a matter of protocol, this isn't the forum for boundary disputes. We have a process." She said process the way people say, "bless your heart." I sat down, started keeping files, manila folders in the top drawer of my father's workbench next to his carpenter's pencils. What I didn't know yet, what nobody knew, was that Diane wasn't fighting over a fence line. She was erasing a boundary, and there was a multi-million-dollar reason why. It started with Gary Phelps, retired electrician, 3 houses in from the Briarwood entrance. He knocked on my door one evening with a 6-pack and a question. "Tom, you know anything about Phase 3? I didn't. Briarwood had 2 phases, 2008 and 2012. Gary told me the board had announced a community expansion, 96 new condominiums on what they were calling undeveloped association land south of the subdivision. A development company, Trident Coastal Partners out of Raleigh, had been selected, permits issued, first foundation already poured. I asked where this land was. He pointed south. My meadow. Next morning, I drove to the Brunswick County Register of Deeds. I've been in that office 1,000 times. I pulled all recorded plot, subdivision document, and tax parcel map touching my property. 2 hours later, I found it. The Phase 3 site plan showed 96 units on 11.4 acres listed as HOA Common Area, Parcel 228R.
Parcel 228R didn't exist. No record, no history, nothing in the county files. Every square foot fell within my boundaries. My parcel, recorded 1947, never subdivided, never transferred. Someone had created a phantom parcel and built an entire neighborhood on it. The fabricated plat came from a firm called Coastal Land Solutions, LLC. No active license. The surveyor's seal had been surrendered after disciplinary action 4 years before the document was prepared. The math didn't work. Bearing calls that couldn't close, a reference benchmark that didn't exist. I've reviewed thousands of plats. This wasn't an error. It was manufactured by someone who'd never set foot on the property. The county processes hundreds of filings a year. Staff reviews for completeness, not fraud. A plat that looks official moves through the system. That's how it slipped through. It was designed to slip through. And then I found the thing that made my blood go cold. Trident Coastal Partners, registered with the Secretary of State. I pulled their annual report. Registered agent, Diane M. Kessler. She owned the development company, building condos on my land using a fabricated survey with permits obtained by misrepresenting ownership. I sat in my truck in the parking lot, cold coffee, did the math. 96 units at $245,000 average, $23.5 million in projected revenue, maybe $14 million in construction costs. Diane stood to clear somewhere in the neighborhood of $9 million. Everything clicked. Every complaint, every certified letter, every visit about my fence. She needed ambiguity. If I'd moved that fence even a few feet, she'd have had a foothold for adverse possession. She was building a paper trail to steal my land. That look passed me on her first visit, past the house toward the meadow. She wasn't there about the fence. She was measuring her future. At that point, what would you have done? She'd made one critical mistake. She assumed the retired surveyor was just an old man who wouldn't check. I contacted Carolyn Wexler, a real estate attorney in Wilmington I'd worked with during my county years. Careful, thorough, unshakable. I brought her everything. She studied the documents for 45 minutes. Then she looked up. "Tom, they built on your land." I told her I knew. "No, they're still building, right now, and every unit they complete becomes your property under North Carolina law." I set my coffee down. She explained it simply. Someone builds permanently on land they don't own, can't show good faith for believing they owned it. The structure belongs to the landowner. Foundation, walls, roof, wiring, plumbing, every structure legally attached to my land, my property. Most cases end in forced sale or compensation, years of motions and appeals. But fraud changes the equation. When the other side's entire case rests on a document that never legally existed, the ground shifts fast. 3 things to prove. The land was mine. Diane knew or should have known. The documents were fabricated. I told Carolyn I could prove all 3, but I wanted to wait. She stared at me. Stopping them early would have protected my land, but waiting would prove intent, and fraud changes everything. If I stopped them now, I'd get half-built shells. If I waited, I'd own everything. She was quiet. Then she almost smiled. You want them to finish. I wanted them to finish. And that's exactly what happened. The next 8 months nearly destroyed me. Diesel engines at 6 a.m., nail guns echoing across my meadow, my creek rerouted into a stormwater retention pond without permission. Diane escalated. The HOA attorney demanded I remove my father's workshop, safety hazard, as a matter of protocol. I measured the distance to the nearest foundation, 340 feet. Legal bills hit $22,000 by December, cash advance on a credit card, no more eating out, canceled a fishing trip. The financial pressure sat in my chest at 3 a.m. and didn't leave when I turned on the light. I brought in Rick Ainsworth, independent surveyor, licensed, no connection to me. 2 days on the ground. His findings matched mine to 0.3 of a foot. Every foundation on my land. He looked at the fabricated plat and shook his head. This is fiction, Tom. Whoever made this never stood on this ground. That's not a mistake. That's a crime. But then, in February, I almost lost everything. Carolyn called, voice tight. Trident had applied to convert Phase 3 into a permanent planned unit development, a PUD. If approved, individual units would get separate deeds, buyers could close, mortgages could fund.
And once families held recorded deeds, even built on fraud, reclaiming those units would go from difficult to nearly impossible. Planning board vote in 19 days. My hands were shaking when I put the phone down. Not the controlled kind, the kind where your body decides something before your mind catches up. I wasn't thinking like a surveyor anymore. I was thinking like a man watching the clock run out. Carolyn said we could file an emergency objection, block the PUD application, buy time, but it would tip our hand. Bulletproof, she said, but we lose surprise, and she starts destroying documents. I told her to file the objection only, challenge the PUD, don't reveal the accession claim, block the conversion, and let Diane wonder why. It worked. Planning board tabled the application. Diane's attorney called it frivolous. The board disagreed. Certified letters stopped for 2 weeks. First empty mailbox in months. Then she overcorrected. One night in late February, 2 a.m., sitting in my truck at the south end of the property, engine off, security lights casting everything orange. Half-framed buildings, lumber stacks, a portable toilet sitting where Linda and I used to watch thunderstorms roll in. I picked up my phone, started to dial Carolyn. 3 digits. I was going to tell her to file everything, right now, take whatever we could get. My chest felt like concrete. 8 months of noise and lawyers and credit card debt and sleeping in 2-hour fragments. I was 63 years old, and this woman had lawyers and money and a board that rubber-stamped everything she touched. Then I put the phone down. Through the windshield, past the lumber, past the orange light, the tree line along the creek. Behind those trees, my grandfather's fence posts, locust, silver, 60 years in the ground. If they could hold, I could hold. Spring, framing done, roofing underway. One morning in April, I walked the fence line and heard children laughing. A model unit had opened. A young couple walked through with a toddler on the father's hip. A woman photographed the kitchen on her phone, touching countertops, imagining their lives. That was the first moment I understood this wasn't just about land anymore. They had no idea. None of them did. And for the first time, that mattered more than the land. Diane made one last attempt, showed up with an attorney and a boundary resolution agreement. I'd quitclaim the south 11 acres for $175,000. For 11 acres with $14 million of construction on it.
I read it standing in my doorway. Took my time. The attorney had a face trained to look patient while calculating. Diane stood behind him, arms crossed, eyes scanning my face like a slot machine, settling. I folded the agreement. No thank you. He started talking about litigation costs. I closed the door. Then, in June, she crossed the line. I came home and found my fence cut, bolt cutters, 4 posts, opening wide enough for a truck. Trail camera caught it. White pickup, Trident Mogo, 2 men, 11:47 a.m. The deputy took photographs, took my statement, looked at the construction site, then looked at me. Mr. Dutton, what exactly is going on out here? Short version. Quiet. Then, you might want to talk to somebody at the DA's office. That evening, porch, coffee, sun going down behind 96 buildings that shouldn't exist. I called Carolyn, told her it was time. And then I told her the part I'd been holding back. I wasn't just a surveyor. For the last 9 years of my career, I was the chief surveyor of Brunswick County. I signed off on every subdivision plat recorded in the county. Catching exactly this kind of fraud, that was my job. And I knew that a plat recorded with a fraudulent seal, referencing a non-existent benchmark with math that couldn't close, that plat was void. Not voidable, void. The difference matters. Voidable means it's broken, but it existed. Void means it never existed at all, like building a house on a map that isn't real. No legal effect from the moment it was filed. Every permit based on it, invalid. Every title derived from it, defective. Every mortgage, every insurance policy on those 96 units built on nothing. Diane hadn't just trespassed, she'd created a legal house of cards and sold units inside it. And the title insurance company, one of the largest in the country, was exposed on every single policy. I could prove it, not as a plaintiff, not as an angry neighbor, as the former chief surveyor of the county where it was recorded. I told Carolyn everything. Long silence. Tom, you've been sitting on this for 8 months. I had. You let them finish building? Yes. On purpose? Construction lights coming on across the meadow, one by one. Yes, I said, on purpose.
Another silence. Then, almost to herself, the title company will come to the table faster than anyone. Every day this stays open, their liability grows. I finished my coffee. First time I'd smiled in months. And that's when her entire world fell apart. 3 quiet weeks. Carolyn filed suit in Brunswick County Superior Court. Quiet title action, trespass, fraud, unjust enrichment. Diane individually, Trident Coastal Partners, and the Briarwood HOA. 42 pages. Referred the matter to the district attorney. Criminal fraud, forgery, filing false instruments. Rick Ainsworth prepared his expert declaration. Told me he'd started writing it the day he finished the survey. He'd been waiting.
title attorney in Charlotte confirmed every commitment on the condos was defective. Carolyn filed a lis pendens on every unit. A recorded notice of pending litigation shows up on every title search, freezes the property. No buyer touches it. No bank refinances it. Without the lis pendens, Diane could stall forever. With it, every homeowner became an interested party. I didn't sleep well the week those were recorded. Kept thinking about the woman photographed in the kitchen, the couple with the toddler, opening letters saying that title was defective. That kept me up longer than anything Diane had done. I went back to the workshop and sharpened a chisel. It was Linda's birthday. I told her what I'd done. She would have called me crazy. Then I told her I was going to get the meadow back. Thursday, Courtroom 3B. Clean shirt, good boots, the ones I wear when I want to feel like myself. Carolyn in a navy suit with 2 banker's boxes. Diane arrived with 3 attorneys, lead counsel from Raleigh, gray suit, monogrammed cuffs, $600 an hour. 2 associates with laptops. They set up like they were preparing for a siege. Diane sat in the middle, back straight, chin up. She didn't look at me, but her hands were flat on the table, fingers spread, pressing down. The way you press down when you're trying to stop something from shaking. Judge Patricia Hamlin presided. I'd appeared before her twice as an expert witness. Thorough, no nonsense. Carolyn presented in 40 minutes. The 1947 deed, 72 years of unbroken title, my surveys, Rick's independent survey. She laid the copyrighted plat beside the real documents and let the contrast speak. Then the Secretary of State filing, Diane to Trident Coastal. Permit applications based on the copyrighted plat. Trail camera footage, 2 men, boat cutters, Trident's logo, time-stamped. Each document placed on the evidence table like a brick being laid, methodical, unhurried. No sound but paper and the hum of fluorescent lights. Diane's lead attorney, 12 minutes, genuinely in dispute, good faith, reasonable reliance 4 times, requested a continuance. Judge Hamlin let him finish. Then she stopped, looked down at the file, turned 1 page. The air conditioner kicked on overhead, too loud for a room that quiet. The courtroom held its breath. I could hear the clock on the wall, a sound I hadn't noticed until that moment. She looked up. "Counselor, can you present any recorded instrument, any deed, conveyance, or plat filed prior to 2018 showing your client as having any ownership interest in the disputed acreage?" He couldn't, not one. "Are you aware that the surveyor whose seal appears on your client's plat surrendered his license 4 years before that document was prepared?" He turned to Diane. She was writing on her legal pad, her hand vibrating, not a tremor, the kind that comes from gripping too tight. She didn't look up. 15-minute recess. The judge gave him 10. Through the courtroom doors, lead attorney talking fast, leaning close, one hand on a chair back. Diane standing very still, arms crossed, staring at a point on the wall 6 inches above his head. Associate already texting someone. You could feel the architecture of their defense collapsing, the way you feel a building settle before it cracks. They came back. Lead counsel said his client wished to explore settlement. Carolyn stood. "We're not interested in settlement. We're interested in a ruling." Judge Hamlin ruled from the bench. The plat is void. Void, no legal effect from the date of its creation, which means, legally, this entire development was built on land they never owned.
Dutton property boundaries confirmed by the 1947 deed and 3 independent surveys. All structures erected by Trident Coastal Partners, permanent improvements to land owned by Thomas Dutton, his property under North Carolina accession law. All 96 units, every foundation, wall, roof, fixture, foot of wiring and plumbing. Every structure legally attached to my land. Mine.
Fraudulent filing. Referred to the DA. Construction cease order. Preliminary injunction barring any transfer by anyone but me. Silence. Not dramatic, just the absence of everything. Argument, strategy, pretense. A door closing for the last time. Diane stared at the order. Her attorneys packed. Lead counsel said something. She didn't respond. Just sat there, holding her legal pad, looking at words that no longer mattered. I stood up, walked out. Carolyn in the hallway. How do you feel? I'd like some coffee. Diner 2 blocks away. Black, white ceramic mug with a chip on the handle, both hands around it. Not talking, just warmth. First time in 8 months I didn't feel like I was carrying something. Word spread before I got home. Gary Phelps at the end of my driveway, handshake he didn't let go of. 11 homeowners that week. Phone calls, knocks, 1 handwritten note. Same message. She did the same to us. Fines, threats, rules changed on a whim. We were afraid to speak. Dennis Ortega, north side of Briarwood, told me Diane had levied $47,000 in fabricated fines over 3 years. He'd kept records. One homeowner, a woman named Claire, stopped me at the mailbox. She said Diane had done good things early on, got the pool repaired, organized a neighborhood watch. She wasn't always like this, Claire said. Or maybe she was, and we just didn't see it yet. I didn't have an answer for that. The 3 remaining board members resigned within 10 days. Diane called an emergency meeting. 14 people showed. She stood at the front with her clipboard. As a matter of protocol, the court's decision is under appeal and the association's position remains strong. Nobody spoke. 11 minutes of silence. She set the clipboard down, picked up her purse, walked out. A full minute of quiet. Then Dennis. So, new business? The kind of laugh that comes when pressure finally breaks. DA filed charges in November. 3 counts filing fraudulent instruments, felony fraud, obtaining property by false pretense. Investigation turned up a prior scheme, Loudoun County, Virginia, 2013, 12 townhome units on disputed land, settled privately. Brunswick was her second attempt. Some people don't learn from getting caught. They learn from getting away with it. Trident filed Chapter 7 in January. Charlotte Mortgage Company sued her personally, $3.2 million. Title insurer joined, moved fastest, just as Carolyn predicted. She lost her license. She lost her company. She lost everything she built on my land. Pled no contest in March, 18 months probation, 400 hours community service, $1.1 million in restitution she didn't have. House on the market in April, sold for less than she owed. By summer, gone. But consequences don't land clean. They never do. Bankruptcy left subcontractors unpaid, local crews who poured concrete and had nothing to do with the fraud. Title mess took months. Homeowners couldn't sell, couldn't refinance. Some blamed me. One voicemail called me a name I won't repeat. I understood. Fear makes people aim at whatever's closest.
Justice has shrapnel. That's what these stories usually leave out. I could have sold every unit at market price, cleared millions. But Carolyn had passed me a folder, letters from the buyers. I read every one. People who had done nothing wrong. People who thought they were finally safe. That mattered more than the money ever did. Worked with a property management firm, affordable rentals, rates a young electrician or nursing assistant could handle. Existing buyers got leaseback arrangements while title issues resolved. It wasn't clean. Some transitions took months. 2 homeowners never forgave me. Being rescued by the person you think caused the flood doesn't always feel like rescue. Gary helped interview the management candidates, wanted to prevent another Diane. I told him one was enough for a lifetime. Rental income funded a scholarship at the local high school, the Linda Dutton Memorial Scholarship. Trade programs, carpentry, electrical, plumbing, surveying, the things that build the world and don't get enough credit. Briarwood restructured, new board, open election, real ballots, term limits. Gary became vice president, hated every minute. I told him that's exactly why he should do it. My creek was restored the following spring. Water found its way back within months. Sounded different at first, thinner, uncertain, like it was relearning its own path. By summer, the way I remembered. I fixed the fence they cut. Same gauge wire, most of a Saturday. My knees complained. I didn't listen. Last October, south fence line, late afternoon. Leaves turning that deep orange the coast gets when light goes sideways. Rooftops visible from the fence. Someone grilling, smoke rising straight. A kid on a bike, a woman carrying groceries. I stood there a long time. Not angry, not proud, just finished. The kind of tired that comes when your body finally believes it's over. There are still 96 doors out there, but I know what's under them. Land doesn't forget who it belongs to. It just waits for someone who knows how to prove it. People just hope no one who knows better ever checks. If you've ever seen someone abuse power and thought no one would stop them, subscribe, because sometimes someone does. Next week, a retired postal inspector discovered his HOA president had been intercepting federal mail for 3 years. She had no idea what that meant. He did.